suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
David Whiting joins you. He is a Melbourne solicitor. He gives free legal advice. Good morning, David.
Good morning, Raf. Nice to see you back in the chair.
Thank you very much. Good to be back with you. Joy is in Ballarat. What's your query for David?
Good morning, David.
Good morning.
I'm calling for a friend. In July, she got a quote from a handyman business in Ballarat to renovate her ensuite. The understanding was that she'd supply all the fixtures and fittings and he would supply the labour. She got a quote from him for $10,900 and there was no GST on that quote.
Yeah.
The requirement was that she paid 30% deposit and there would be a 5 to 6 week delay in commencing. So she paid $4,400.
Wow, yes.
She went on holidays in September, and when she came back, the work hadn't started, and she asked him whether the tiling was going to go to the ceiling, which they had previously discussed. So he disputed that, and so then he sent her a new quote for $14,568, which now included 20% GST of $2,428.
The only problem is the GST is 10%. Perhaps he's running ahead of the government, do you think, Joy?
I think he might be. And the other thing is I checked and he's not registered for GST anyway.
Oh, well, that's an offence for claiming GST when you're not registered. Joy, I would be getting my money back and dealing with somebody else. And
well, that's what she's trying to do, but he's refused to refund the deposit.
I'm sure he has. But to me, you could go to VCAT and say that, although I've got to tell you, delays in VCAT are roughly 2 years, all right?
Yes, and we've been to the domestic dispute, which you have to go to first.
Oh, you've been there already?
And they've just advised that it's at least 16 weeks, and maybe we should try negotiating ourselves. Well, she tried. She got a friend who's a project manager to call him, and he was very abusive and hung up.
Joy, I don't know how much money your friend has got, but I would be inclined to formally terminate the contract, require a refund of the money, issue it VCAT, and then go off and get the work done by somebody else and don't make the recovery of the $4,400 the essential part before you start, but rather when you get to the end.
Well, the problem is it's a money issue, of course.
Yes.
But you've done the domestic disputes thing at VCAT.
Yes.
You've exhausted that option, have you? Oh, your friend has.
I describe that as an invisi-queue, Raph.
Yes, I heard you say that previously, and probably you're correct, because you can't go to VCAT until you've been through that step.
Well, you can, but you'd be mad if you did. And the answer would be it just hides matters before they get to VCAT.
So I guess short
answer is
there's not much you can do?
It's not this year's project, Joy.
Yeah.
Right, so no, not going to a lawyer, perhaps, and try and go through that channel?
My view would be issue the VCAT proceeding and look at a lawyer down the track.
Lawyer's going to end up costing more.
Yeah, but the lawyer's going to end up costing you more than the $4,400. That's my problem.
Good luck, Joy. Thanks for a really good description, though, of the issues. I'm afraid I don't see too much, or David doesn't see too much there. Malcolm's in Arthur's seat, though. Malcolm, go for it.
Oh, hi, David. I'm an executor of a will, quite a complex will. There's 3 executors. And one of the components is that some great-grandchildren have been left a small amount of money, several $1,000s.
Yes.
The issue is that some of them are they're basically newborn.
Yep.
And they don't receive the money till they're 21.
Mm-hmm.
And we're just worried that if we have to set up accounts and administer that for the next 20 years, that their several $1,000s will probably just buy them a cup of coffee in 20 years' time.
Yeah, quite possibly. Malcolm, I would be looking at it from a different point of view. You promised to execute the terms of the will. You've got to give effect to the gifts. What I would be suggesting is that you that you appoint the parents of the children to be the trustee of the fund. So let's say it's $5,000 for a great-grandchild. You appoint the parents of that child, so you retire, the 3 of you retire as trustees of little Johnny's trust fund and appoint Johnny's parents as the trustee of the fund, assuming they're willing. Tell them they need to open a separate bank account and they need to invest the money. What I've tended to recommend, although I'm not a licensed financial advisor, so I've got to be very careful, is to consider an investment that will offer some capital growth as well as some income growth. So it might be a managed fund, it might be shares, it might be something that gives them a return that will grow rather than just sit in the bank and get 2 or 3% a year interest.
Yes.
Does that answer your question?
Well, it does. I guess there's a second part. I was advised by a neighbour that there's an instrument called a deed of family arrangement. And
Yes.
he said he'd use that in a similar situation.
But the problem, Malcolm, is that you can't take the money away from the great-grandchildren.
No.
So for
I guess-
people who are sui juris, above age and with capacity, they can negotiate away anything.
Yes.
You just can't negotiate it away someone else's anything.
Yep.
Makes sense?
Okay. Yep.
Yes.
Thank you.
Good luck. Thank you, Malcolm. Tony is in Kinglake. What's the issue, Tony?
Good morning. Thank you for taking my call. I received an infringement notice for a drink driving offence 10 days ago. The problem I have is I'm a guardian for a lady who's in care.
Yes.
I'm wondering if I can go to court and plead guilty, whether the court will look poorly upon this, whether I'm likely to get further penalties.
Well, you're only likely to get more, Tony, but the practical conclusion is you're not going to get less. What did you blow?
I was actually sleeping. I slept in the car, but not for long enough.
Yeah, 2 or 3 hours short. Tony, you're going to get the same penalty.
Yeah, I understand that.
And so I don't see it will make any difference. If you're pleading not guilty, you'll be able to keep driving for a bit longer, but at the end of the day, the penalty will be identical.
The other problem I've got is the lady's miserable where she is, and I need to look for other places for her to go. And I'm dealing with an appointed trustee as well.
Then you're going to need to get some assistance to get you around to look at the properties. You just, and from the time your licence goes, you can't drive. It is just not worth it.
I know. I'm just wondering if I go to court and get a bit of extra time.
No, they can't. They can't say, we're taking your licence, but it starts in a fortnight.
Yeah, they won't do that.
They can't do that. Once the finding of guilt, you've lost it.
Good luck, Tony. I'm sorry about that. Very rare to get an exemption for that one, isn't it, David? We've had a few.
No, it's impossible.
Oh, sorry. Okay.
Okay.
Wrong words.
Yeah.
Impossible. Elizabeth's in Seymour. Go for it, Elizabeth.
Good morning, Raph. Good morning, David. My question is to do with a will, again. I'm a beneficiary of my late husband's will, and there are 2 other beneficiaries, but that will has been challenged.
Yes.
And I would like to know if an agreement is reached between the complainant and the 3 beneficiaries. Does it have to be every beneficiary agree with the agreement?
Technically, are you all residuary beneficiaries for a third?
No, I'm the main beneficiary.
Then
The
what
other
will
2
happen, Elizabeth, is that you will be invited to be a participant in the dispute.
Yes.
The general proposition is that it gets a bit... when the matter goes to court, the court issues an order that you be formally advised of the proceedings and be invited to participate. But you need to remember that in the event that there are multiple beneficiaries with essentially the same interest, they won't get multiple costs.
Yeah, the other beneficiaries are not people; they're organisations.
And is it someone else who's come along and said, I want, is that right?
Yes.
Okay. What you should do is be discussing your position with the executors and trying to make sure that it's a very unkind thing to say, but charities are seen as not having an entitlement or not having a particular value.
Yes, I thought of that, which is why I'm asking you about, how much say am I likely to have in this?
Well, there's a negotiation between you. The expectation would be that everybody would be impacted to the same extent. So if they lost 10%, you'd lose 10%. If they lost 20%, you'd lose 20%.
Yes.
Make sense?
Yeah. Well, my position here is I would like the will to stand as it is written.
Oh,
Yes, what the executor's in a really tough spot. The executor has to say, well, did the deceased fulfil his or her moral obligation to the beneficiary? And if not, then the executor's obligation is to resolve the issue as quickly as possible, even if it means taking something from your share, Elizabeth.
Good luck, Elizabeth.
Yes.
Thank you.
Right.
Good luck.
Okay. Thank you. Bye.
Just on the issue we had earlier with the bathroom work, Rob's got this in Willert. Rav had a similar issue with a gardening contractor, applied to VCAT, sent copies of the application documents and had the money back in 7 days. So sent copies of the VCAT application documents, got the money, although I think our caller, her friend, had gone further down the path.
I think so too. Yep.
And this is addressed to you. Come on. InvisiQ is derogatory to all public servants who do the hard work to resolve issues before they get to VCAT. Public servants are not a punching bag for lawyers.
Okay, I accept that. Except my view in relation to the dispute that they have I think is a pretty low success rate. And I think in part that's because the parties to a dispute tend not to focus on the resolution at that stage.
Sure.
It's when someone's about to order you to pay some money, or somebody asks you to pay a big amount on the costs, you tend to focus more, on resolving the issue.
You do. We'll get to more calls with David Whiting in just a moment.
Hi, it's Rochelle Hunt. Can you believe it's already January? If you're lucky enough to get a break, this could be the perfect opportunity to catch up on the Conversation Hour podcast. There are so many great episodes to choose from concussion in sport to drug and alcohol testing at work, through to supporting people living with dementia. And if you're travelling, you can save episodes to your phone. Just open the ABC Listen app and search The Conversation Hour.
Join in the Melbourne conversation anytime.
Call 1300 222 774.
Or text 0437 774 774.
ABC Radio Melbourne.
Now we're talking.
David Whiting is answering your questions. Sandra is in Fitzroy. Sandra, go for it.
Hi, David. Thanks for taking my call. I had to replace my car battery recently, and it was not a branded battery. I've had subsequent issues with safety in the car, driver's assistance type issues. I've contacted the dealer, and they said because it wasn't a standard branded authorised battery,
So
it was going to cost...
When you say the dealer, this is the car dealer, is that right?
Yes, the car dealer. And
Yes.
so when I contacted them to see whether the issues with the car could be repaired under warranty, they said because it wasn't an authorised battery, I had to pay $220 to get the car recoded. Now, the car's still under warranty. Does that... the fact that it's not an authorised
Sandra,
battery...
that makes no sense to me. There have been lots of issues with the ACCC and in the courts relating to dealers requiring you, car manufacturers requiring you to get all your maintenance done at a dealer. And there are lots of other places you can take your car to, provided they do the book service as it's required at the mileage. That does not in any way invalidate your warranty. Have a look at the book and see if there is a requirement that you use a particular kind of battery. And then I'd be going to the people you bought the battery from and say, well, does it meet this specification? And then go back to the dealer. Because if there's no requirement in the book that you use a whatever it happens to be battery, I think they're not entitled to make the claim they are.
Okay, because when the battery actually when we were aware there was an issue with the battery, we tried to book in a service, and it was a month before we could get in, and it was just too long for us to wait to get in with the dealer. So we just went and replaced the battery on our own.
Which I think entirely... I would be going back to them and putting it there. So I take it that some codes have fallen off the car because you didn't use because of the battery you'd chosen to use?
Well, from my Google research, I understand that modern cars these days have to be recoded, which is basically just giving a serial number and other specifications to the battery for the car.
Yep.
Now, I don't know whether that has impacted some of the safety systems in the car. That's wrong. I'm willing to.
I mean, Sandra, I would be paying the $220 for security and then dispute the payment.
Okay.
And then say, now you've got to give me back the $220 because you're being unreasonable. But I would be worried about your safety issues as you are, and whether everything is coded or not coded properly. That's where I would take the issue.
Good luck.
Okay. Thank you.
Thank you, Sandra. Rebecca's in Thornbury. What's your issue, Rebecca?
Hi, yes. I have a business that uses a platform for booking, taking bookings. And when a customer books with us, they get a confirmation email to say, you're booked for this date. But if we cancel that service, the operator of the platform is telling me that the system can't automatically email them to say it's been cancelled because they haven't opted in to receive updates regarding their booking. And for me, that's madness because my customer would want to know if we're cancelling a service on, their behalf. But
Are they saying it's a breach of privacy?
Yeah, because they haven't opted in to receive updates about their booking.
So you make a booking on someone's behalf, is that right?
No, they can get online and make the booking. So say it's a class, like it's a yoga class.
Yes.
And they book in, they'll get an email to say you've booked into such and such a class.
So they book into Rebecca's class. Rebecca has to cancel the class. You want to notify the attendees that the class isn't now running.
That's right, yep. But they're telling me that we can't do that because they've opted out of receiving up their schedule.
I don't see that as a mailing list question. It's not a bulk mailing issue. I see it as being fairly straightforward information about your booking as opposed to a general promotional item for Rebecca's yoga classes.
And that's a conversation I had with them, and they said, well, that's what the law says. And I'm like, I don't think the law would say that because this is regarding a booking they've made, not something I'm trying to sell them.
Rebecca, I'll try and give you some chapter and verse next week, all right? So I'll look at the privacy principles and come back to you.
Perfect. Thanks so much for your help.
Thank you, Rebecca. David's got some homework. Noel is in Warrigal. Noel, go for it.
Yes, David, thank you for taking this call. I just wanted to elaborate on what you spoke about last week as far as rights of interment.
Yes.
My grandmother passed away in 1980s and my father had the right of interment. He passed away in 2013 and after talking to the Cemetery Trust, they told me the right of interment for her grave site, my grandmother's, had been signed over to a third party and couldn't really tell me who. My question is, should that right of interment been gone to the beneficiaries of my father's will?
It should go to the executor of your father's. Well, sorry. The premise I've got is this, is that your grandmother was buried in a grave that in respect of which your father held the right of interment.
Correct.
Now, what then happens is the right of interment then belongs to your father's executor.
And the executor has signed it over to a third party.
Well, then that's an issue you take up with the executor.
Okay.
Now, the executor may have given it to a group of beneficiaries, may not have, but it's essentially the executors to deal with.
Okay, so they can pass it on to anyone they like.
Yes.
Because my dad, in your case, my dad kept hold of it so there'd be no disputes, and now I feel like it's been passed on to a third party that, a dispute.
Well, but it won't be just a third party. It will be presumably a third party with some interest in the grave.
Okay.
Just not the same as yours. Yep. The other thing I would ask you to check, though, is why don't you ask the executor who the right of interment has been transferred to?
That was a messy situation. We haven't spoken since our father passed away, and she sold everything and never, it was a messy situation.
Yes. Well, I got to tell you, you're going to get more probably a better result from a phone call to the executor than you are in a phone call to me.
Yep. All righty.
Good luck,
you,
Noel.
Thank
Thank
you.
you. Good luck with that. Does not sound easy. Rob is in Rosebud. Rob, what you want to add something to the car battery question?
Yeah, that's correct, Raf. In regard to that car battery problem with the lady, it's nothing to do with the dealer. When you replace a car battery in a modern car, you need to keep continuous power to the car. So a good battery dealer, just an actual battery place, will put a device on that puts a power supply into the car before they remove the original battery. It continuously keeps all the codes and everything going in the car. They then remove the old battery, put the new battery in, connect it up and everything, and then remove the external power supply. Nothing is interrupted. Everything is fine. The dealer has nothing to do with it because the dealer is going to say, well, okay, you've messed up.
So Rob, the issue is not with it was an unbranded battery.
No,
the issue is the way it was installed.
Exactly.
In which case, Sandra has no right to complain about the $220 other than with the person who put it in.
Yeah, what she needs to do is go back to the battery. If she did it herself, it's bad luck for her.
Yep.
If she got the battery from and replaced at a proper battery dealer,
understood. Yes.
She needs to go back to them and say, this has now cost me $200
yes.
for something that you've messed up. I want to have some recompense on that.
Yeah, interesting. So that's the issue is the power source keeping on going while the battery is replaced.
Maintaining current to the car. Thank you, Rob.
Right.
Thank you, Rob. Appreciate the call. Thanks a lot. Stuart is in Melton. Stuart, what's your query?
Yeah, good morning, David. Got a situation of a enduring power of attorney financial, which was conducted in 2007.
Yes.
And unfortunately, it was the two attorneys were selected, and one of them has recently passed away, and it was specified as they had to act jointly. Is the power of attorney still valid?
Yes, it is. But it's now a power of attorney in favour of the sole remaining attorney who is alive.
Okay.
So the trick in using it is you're going to have to prove the other person died.
Oh, that's quite simple. It's one of the person's daughters that has passed away.
Okay. But yes, there is a power of attorney in place. It's now in favour of one person instead of two.
So even though the law changed in 2014, if this is a 2007 power of attorney, there's still no issue?
The 2004 Act came into effect in 2015, but all of the earlier powers of attorney, whether they were made under the Instruments Act any power of attorney made prior to the Powers of Attorneys Act is still valid according to its terms. They're grandfathered in.
Okay, and it would be similar for the medical treatment power of attorney, I assume, with the two...
Well, that's changed completely. Now that's the appointment of a medical treatment decision maker, but the medical treatment powers of attorney are still valid. So they keep going. They didn't fall away just because the legislation changed. You just had to now do them in a different way.
Okay, so we shouldn't have to do any further paperwork at this stage?
No.
Okay, appreciate your help.
Pleasure.
No
Thank you, Stuart.
Good luck. Thanks, Stuart. And just a precursor to your homework.
Yes, sir.
The booking service. Rebecca's problem is not, this is from Antoine, Rebecca's problem is not a Privacy Act problem, it's a Spam Act problem. The service provider has got it wrong. The messages are not a commercial electronic message. They're an information message. Therefore, they're not subject to the consent regime in the Spam Act. Is there a Spam Act?
It won't be called that.
No, but there'd be something that covers spam. Right, there you go. So there you go. That's your beginning of your homework.
I thought my homework's done.
No, your homework's not done. That's the taster. Thanks so much. David Whiting there answering your questions as he does every Tuesday.